if you look at the Act as a whole, the Act is a sort of manifestation of the views that the Gill Review took, that cases should be moved lower down to a level that's more appropriate, take cases away from the higher courts, and beef up, for want of a better term, the sheriff courts, and also introduce some procedures for dealing with low value cases. Well, the most obvious significant provision is the provision about exclusive competence. And the Act provides that you cannot raise an action for under £100,000 in the Court of Session, that you have to raise it in the Sheriff Court. And the obvious intention is to divert any cases, or to divert a large number of cases that would otherwise have gone to Court of Session into the Sheriff Court. And it's simple as that, and it remains to be seen just what that will mean in terms of figures. There's another aspect to that, which is that although you can't raise an action in the Court of Session for under £100,000, there are circumstances in which you can raise in the Sheriff Court, but you could transfer or remit a case to the Court of Session. And I'll mention that later, because there are provisions about transferring cases up and down the hierarchy, which again are designed largely to try and keep the cases at the lower level, if at all possible. The information technology is not mentioned very much in the Act at all. Everybody talks about it and how we will get ourselves into the 20th century or the 21st century with information technology. But it appears to me that at the moment we're a long way behind other systems in the use of information technology. And I think that it's a very, very long-term aim. So the Act actually, for example, whilst we all want to use information technology in the courts, the Act doesn't say very much about it, and I think it's the Scottish Civil Justice Council who will pick that up. But that's not likely to happen, I think, in the very near future. Having case management systems in the courts, whereby they can control the litigation. The information is all going to be available electronically, and I suppose in the fullness of time, allowing people access to the court systems from outside, allowing people, for example, to lodge documents by email. There's discussion just very recently about online dispute resolution, which may or may not have something to do with the courts. The unfortunate thing is, if you look at Scotland and compare it with other countries, then we're a long way behind with that. Well, the Act empowers the Scottish ministers to direct that a specified sheriff in a specified sheriffdom can have an all-Scotland jurisdiction over specified types of proceedings, effectively. And the easiest way to illustrate that is in relation to personal injury work and personal injury cases. The Act simply gives this enabling power that you can have a court with all Scotland jurisdiction. In other words, it will hear cases regardless of the fact that they're out with the territorial jurisdiction of the court. This was brought in order to accommodate personal injury actions. There are particular reasons why the personal injury actions were considered to be appropriate for this, and that can be gone into separately. I don't think it's terribly important. But the Act entitles the court, entitles the Scottish ministers to say that anything can be given, any court can be given as an all Scotland jurisdiction in relation to particular areas. Now, the prospect of that happening is quite remote, I think. But what was underlying this idea was that at some time in the future, it may be that one could give, let's say, all Scotland jurisdiction for adoption cases to Perth Sheriff Court. And that would be a sort of decision that we're going to have a specialist court dealing with adoptions, let's say, in Perth. We will have specialist sheriffs, and they will sit there and they can hear cases from anywhere in Scotland. So there is an idea, which is in some of the literature and some of the government papers, about having justice centres or something of that kind, where people can go and have specialist sheriffs dealing with specific types of cases. I think that's a long way off, but there certainly has been discussion about that as an idea. What's happened is that the Act created what's called the Sheriff Appeal Court, and that's an interesting body just from the point of view of the structure of the justice system and looking at the constitution of the Sheriff Appeal Court. That's quite interesting as well. The concern in broad terms was that perhaps too many cases were going on appeal from the Sheriff Court to the Court of Session. It was clogging up the works in the Court of Session, and a decision was taken that there ought not to be that automatic right of appeal to the Court of Session from the Sheriff Court. And what was considered appropriate was to introduce a new appellate court, which is the Sheriff Appeal Court, and if you like, your first port of call, if you want to appeal from a decision of the Sheriff, is now the Sheriff Appeal Court. And the Sheriff Appeal Court was set up, it comprised a president and a vice president and a number of judges who would sit in the Sheriff Appeal Court. The judges who are going to sit in the Sheriff Appeal Court are all sheriffs principal or sheriffs who have been nominated as Sheriff Appeal Court judges. And the Act sets out the framework within which the Sheriff Appeal Court is going to operate. The actual management of it on a day-to-day basis is under the control of the President, and it again remains to be seen what will happen with the Sheriff Appeal Court. They've also introduced, to supplement that, the new rules for the Sheriff Appeal Court, which contain quite detailed provisions about how you appeal and what procedure happens during the appeal. And those rules came out sometime after the Act was passed. They're now in place. The Sheriff Appeal Court has been in existence for 2-3 months now on a civil basis. I haven't heard anything yet about what's happening with it, but it's going to be very interesting to see how that operates and whether that introduces a level of appeal which will be satisfactory and which will reduce the appeals from the Sheriff Court being heard by the Court of Session. I mentioned earlier on the idea that we want to try and have cases dealt with at the right level, and that means cases will be going to the Sheriff Court. The Sheriff Court's busy, and what the Act brought about was they brought about this new status of sheriff, this sheriff who's called a summary sheriff. And a summary sheriff will hear a number of cases, but insofar as the civil is concerned, the sheriffs will hear simple procedure cases. That will be the low value cases, the cases which at the moment would be £5,000 and under. And they'll also undertake other pieces of work, such as, for example, granting warrants where some personal appearance is required, and other types of work, to effectively free up sheriffs for doing, I shouldn't say more important work, but perhaps more valuable work. And the idea behind that being that the Sheriff Court is, in any event, fairly heavily burdened with work. The reforms are going to increase the work that's going there, and the summary sheriffs are being brought in to take away some of the lower value work from the sheriffs themselves to free up their time. So you can look at this, and in fact there are provisions about the organisation of the Sheriff Court as well, as effectively streamlining the Sheriff Court so that it's able to receive these cases and able to conduct them in a way that's going to be more cost effective. So that's where summary sheriffs come in. It's an additional sheriff who's been brought in, and they'll deal with cases at a slightly lower level. And the Act provides that they can actually change the kind of cases that can be dealt with. So who knows, in the fullness of time, summary sheriffs may increase their own jurisdiction and be involved in other cases. It doesn't mean that the sheriffs, the existing sheriffs, don't deal with or won't deal with low value cases, but the idea is to introduce these people who will take away some of the less important work, if you like, from sheriffs. So that's what the summary sheriffs are all about.